When violence is seconds away, the police are usually minutes away. In that terrifying gap, you are entirely on your own. The law recognizes this reality. Under India's new criminal code, the Bharatiya Nyaya Sanhita, or BNS 2023, the state acknowledges your natural instinct to survive. Section 34 lays down a simple rule: fighting back to protect your body, someone else's body, or your property from unlawful harm is not a crime. This legal right grants you immense power. In the worst-case scenarios, it even protects you if you kill your attacker. But that power comes with a strict, invisible boundary. Cross it by just a fraction of an inch, and the law stops seeing you as a victim and starts prosecuting you as a criminal. Self-defense is never a blank check. It operates on a precise legal scale. If you don't know exactly how to navigate it, surviving an attack might only be the beginning of your problems. The baseline of this scale starts at Section 35. This gives you the universal right to use non-lethal force to deflect standard threats against your physical safety or your belongings. Under Section 36, this baseline right holds up no matter who the attacker is. Even if the assailant is intoxicated or mentally unstable or a minor, you are fully permitted to defend yourself. But at this level, your response must remain strictly non-lethal. You can shove a pickpocket away or wrestle them to the ground, but you cannot pull a deadly weapon on them. Baseline defense is entirely about deflection and restraint. To legally justify moving up the scale to lethal force, the threat has to mutate into something far worse. The peak of the escalation scale sits in Section 38. This is the specific legal threshold where you are permitted to take a human life to protect a body. The primary trigger for this is grievous danger. This means an assault that creates a reasonable, immediate fear that you are about to die or suffer a severe, permanent physical injury. The law also automatically applies this lethal threshold to specific heinous crimes, including an attempted rape, an acid attack, or a kidnapping. The final trigger for bodily defense is wrongful confinement, but this only applies if you are trapped in a way that makes it completely impossible to reach public authorities for help. You also have a right to protect your property, governed by Section 41. But lethal force here is reserved for absolute extreme scenarios. Specifically, the law protects you if you use deadly force to stop an armed robbery or against an arsonist attempting to burn down a dwelling or tent. There is also a very strict nocturnal condition for home invasions. Lethal force against a break-in is legally justified, but only if the intrusion happens after sunset and before sunrise. The right to use lethal force is exclusively reserved for moments of terror when you face an irreversible threat to your life, your limbs, or your sanctuary. You have to make these decisions in a split second, but the courts will spend years dissecting them. They judge your survival actions retroactively against a rigid set of limits found in Sections 37 and 40. The first limit is proportionality. Your defensive response must strictly match the threat. If someone slaps you and you retaliate with a deadly weapon, the law treats that as murder. The second limit is the duty to seek help. If you have the time and safety to contact the authorities, like locking your door during a disturbance outside, you cannot actively choose violence. The third limit, established in Section 40, is the expiration date. Your right to self-defense is strictly tied to the immediate presence of danger. The second an attacker drops their weapon or turns to flee, your legal right to use force drops to zero. If you chase a fleeing attacker down the street, you are no longer defending yourself. You are committing the crime of assault. Under the BNS, self-defense is a temporary shield granted by the state to keep you alive. The exact moment you try to use it as a sword for revenge, it vanishes.